Hi, my name is Christine Marfut, and I'm bringing you a documentary tonight about HOA fraud. It is rampant across the United States. There are over 1 million hits on the internet. It's a fraud that should be prosecuted as fraud, but it's not. And homeowners are facing experts in the legal field. Also, we as homeowners are expected to hire lawyers. We can't afford lawyers. The other side, the HOA, doesn't pay for these cases. The homeowners association, the homeowners themselves are paying to be sued. It's a very unfair fight, and there is so much money involved. I had an email from a Texas lawyer who called it a crime syndicate. She said it's happening in way too many HOAs. They are taking houses from families, from the elderly. They are affecting people's ownership of property. They will never again be able to own a house. Their children will lose their inheritance. And this is over things that are made up. And I hope whoever is watching out there will do something to investigate this racket. Tonight I'm going to show you some of the cases across the country and my own case, and you be the judge of whether this is fraud, mail fraud, extortion, trying to get property, trying to kick me out of a fully paid for house. Thank you, and I hope you watch and tell your friends.
Correct. Would you raise your right hand, please? We're going to put you under oath. Do you solemnly swear or affirm that your testimony here today is the truth, the whole truth, and nothing but the truth?
That is correct.
Thank you, sir. Real quick, and thank you for being here. Since the beginning, I will tell you, Mr. Rogers, now that you're here under oath and in front of us, your law firm was very unwilling to cooperate with us. I personally spoke to, not you, but one of your attorneys on one of them. And my question to you is...
Can I respond to that?
Absolutely, sir.
For the record, I would like to establish that I have had dialogue with Mr. Bond on several occasions, and that I have written to your office as well, and I have left an outstanding offer to be available to speak with you.
And again, after second notices, I have copies of our correspondence back and forth to you, and this is a message for you. I'll ask you the question, and I'm going to make a statement. Why do you feel that your law firm tried, and we have it in black and white here, every excuse why not to show up at these meetings? Why did they try to find every loophole, every misdirection, and where we're not an association, we're a homeowner association? Why did your law firm take that approach instead of working amicably with us?
You said you wanted to... I did try to address that.
For the record, since we've been working this case for a while, that was after the second attempt to try to...
That was after the subpoena was served to discuss the language of the subpoena.
Representative, you understand, you're an attorney, sir.
Right.
My point here is that it shouldn't have to get to the subpoena. This is a group trying to take in voluntary information. We're asking you, if I were an attorney, sir, I would just, as soon as something came, especially from the state of Florida, this is serious business, I would be on the phone calling my board of directors and the property management company and saying, gather up all those documents that for years or for months were not provided and comply with this group.
I appreciate how you would approach it, but I have to tell you that in the world of legal practice, you probably wouldn't retain clients very long if you told them what to do. Because an attorney isn't there to tell them what to do, it's there to advise them. And when a client says this or that, and I'm not suggesting they did in this instance, I can only offer advice. I do not make...
Mr. Roger, have you ever been in front of a committee like this? This is a committee that is set up to withdraw information to help people when they've had problems. So I think that, give you the benefit of the doubt, we respect what you do as an attorney, but this committee is unlike getting a complaint, which, by the way, attorneys constantly disregard what DBPR tries to do also. But that said and done, this is a committee that's trying to gather information. By the way, we didn't just choose cases at random. We have taken on these cases because for months and at times years, people by certified return receipt mail have requested documents, and your clients have refused to turn them over.
Well,
and that is where we're at. That's why we're here today.
Let's talk about that.
Please
First
do.
and foremost, I think, from what I understand, you use a basis of number of complaints received over a period of time. Is that correct?
That's correct, sir.
All right. Do you look to see how many come from a variety of members, or if they're focused on one or two individuals?
We sent you guys.
I am not denying that you sent requests.
Well, again, we're asking for cooperation, sir. Questions?
And I am here cooperating.
We've had numerous people come to us and say, I don't want to go to the administrative law judge hearing because I don't want to face the potential of having $40,000 or more of attorney's fees awarded against me on an appeal. The way that I understand it, the administrative law judge statutes allowing for that procedure was supposed to be an avenue for the homeowner to go to outside of court, to go to and be able to resolve their disputes without worrying about attorney's fees. And what we've seen happening is once the issues are decided at the administrative level, those issues are appealed, and the attorneys for the homeowners associations are submitting applications for attorney's fees if they prevail in the appeal. And those applications for attorney's fees span from anywhere from $1 to I've seen upwards of $50,000. So it's scaring away the homeowners, and it's effectively defeating the original intent of the bill that was passed last year. And I'm available for questions if there are any.
Thank you. Any questions for Mr. Goodman?
Thank you, sir. Appreciate it.
This is a dramatization of what is going on across America, and in particular to me.
How you, Miss Lotta Moneymaker? How you doing today?
Hey, Mr. Swampy, Sylvester. I'm so glad to see you. How are you, and how is your partner, Pete Bogg?
Fine as frog hair.
Mr. Swampy, I'm so glad you came by. I was just about to mail your check, and it's a big one. You know, we added a little extra to cover your taxes. It's not our money. It's the homeowners' money. And if we need more, we just charge them more.
Well, thank you, Miss Lotta. This is going to turn out to be a profitable arrangement for the both of us.
And the poor homeowners won't know what hit them. They'll lose their houses and their life savings and their children's future. There'll be nothing left for them to inherit. They'll never be able to own another house because we'll ruin their credit. And the homeowners in our association will be left holding the bag. You know, we make up most of this stuff, and then we take them to court. They can't afford a lawyer, and that's where you come in, my dear. You are so good at taking their houses. You know, They will never be able to afford another house. Their credit is ruined. And when you sell them for pennies on the dollar, they're left holding the bag. They owe attorney's fees, and they owe their mortgages, and they owe the fines that we still charge them. There will be nothing left for their children to inherit. They will be ruined for the rest of their lives and will never have another house, but we will.
By the way, Miss Moneymaker, do you have any more coming up?
Oh, we have somebody who planted flowers, and we call them weeds, and we will fine them, and you can sue them and run up your attorney's fees, and we'll charge them so many fines plus interest, and they won't know what hit them. They'll be out of their house before you know it.
You know, the straw man, Mr. Pie, he bought that last house for $1,400, pool and all.
I bet he was the only bidder. And did you say there was no mortgage on the house?
No, indeed, and that's the best kind.
I'm sure he will express his gratitude to you.
Yes, he's selling me a yacht, dirt cheap, just like I got the house.
And the homeowner will be left owing the difference.
Oh, Miss Moneymaker, by the way, I do have some cash for you.
Ooh, my favorite color, green. I thank you, Mr. Swampy. Let those homeowners eat ramen noodles for the rest of their lives. This is wonderful.
Oh, by the way, you want to go to lunch with me?
Where would you like to go?
Oh, let's go to the Turtle Club.
Where else? Oh, I just love their lobster. Let those homeowners eat ramen noodles. Thank you. You're so good to me, Mr.
Well,
Swampy.
Come on, we're going to go.
Okay, I'm coming.
There it is. Got the money?
You do, honey. We
Oh.
both do.
All right, let's do it.
Okay.
Just stop by here to check out our new yacht through our HOA, acquirement. It's great. We're going to have great fun here. Can't wait to see you again. Take it easy. Bye.
On down to the river to wash my soul again. I've been running with the devil, and I know that he's not my friend.
I got to feeling mighty ashamed because I was too scared to protect what was rightfully mine. Mighty ashamed.
Yeah.
I felt so low that a little bitty ant couldn't have walked under me. And I tried every way I knew to get shut of that feeling, but I just kept feeling lower and lower. And then one day when I was in school, the teacher was telling us young'uns about how this country of ours begun, and she told us about this fella that says millions for charity, but not one penny for tribute. And then she explained to us what that meant.
What does it mean, Pa?
Well, that means that it's fine and dandy to give away something because you want to, but not because you're scared the other fellow's going to give you a punch in the nose if you don't.
Mr. Trump, I know that you know what Wadar Medawani means, for we were both raised by Scottish mothers. There's something deep inside me that has a kinship, too, for what Andy Griffith was saying. I cannot let anyone steal from me, and what's worse is they're stealing from what my mother worked so hard to leave me. I want to read you a poem, very short, the first lines, but it's very appropriate to what's going on, and it's written in the traditional Scottish dialect. My castle is I mine, and harried it never shall be, for I mun fa ere it's taken. Wha dar meddle with me. So I must fall before it's taken. Who dares meddle with me? I must fight this. This is theft. It is a racket, and you will not get my property, Gardens of Gulf Cove, and lawyers, Najmi Thompson, without as much of a fight as I can give you. Does the cover of this book look familiar? Gardens of Gulf Cove. This man sued this community in 2010, spent his own money. He was concerned because his neighbors, elderly people, were being sent $250 attorney letters, which is against the Fair Debt Collection Practices Act. I will discuss that further. But they were threatened with foreclosure if they did not pay these amounts. He has a letter from his former neighbor who was crying. Currently, she's approximately 94 or 95 years old. Mr. Kalyani, the author, is 89. Through this book, he talks about how as a child under fascism, he hated it. And he is trying to warn the country by writing this book that we are becoming a fascist, socialist nation. I am about to interview Bill Kalyani. This is his book, Democracy or Dictatorship, and he wrote it about the subdivision where I live, which is called the Gardens of Gulf Cove. Well, I just wondered, basically, if you wanted to say anything about Gardens of Gulf Cove and your experience with burns.
Okay, let me go first to the gardens, and I wish they have a chance to see this tape eventually, so I can say hello to them at the same time they can go to hell, as far as I'm concerned, because they're not fit to be proper humans, in my opinion. They're a bunch of racketeers. I think they're doing to enrich either their pockets or their morale, but that's about the size of the way they operate the place in there. It's a trap, and they use the trap to their benefit. And they use the people, the members, as cash cows to benefit whatever they choose to do. That's as far as the garden goes. Cove. Now, incidentally, I would like to send them a message. I do not have to be present. My case can be reopened at any time because their friend Judge Burns removed me from the case because we attended mediation. The reason why people go to court is because mediation failed. So that shows there is a jackass or an incompetent judge that doesn't belong in there. Or he's paid off. Tell them to take that pic.
I paid them everything, and they said I didn't, and that's where, but they don't care about the payments. It's just they want the house. That's where the payment is.
Well, naturally, they're not going to be happy with. That's the American philosophy. I got 10, but I want 20. But then I'm not happy with 20. I want 40.
Oh, I know.
80, and so on and so forth.
Yeah.
What they did on my case.
Yeah.
They increased the rules without the voting. They elect without the proper voting. They falsify ballots. Why call it homeowners association? We should call it homeowners disassociation.
Well, how did Judge Burns, what did he say to you? He said that you had to get off the case?
Well, he removed me from the case by order, because we signed the documents of the mediation. And I didn't want to appeal the case because I had a poor lawyer. I had a bad lawyer to start with. That was the main thing. I sensed it, and I figured let it play as it is instead of continuing. That was going to cost me that much more money. But forget, that case cost me $56,000.
Oh my goodness! Of your own money?
It cost me a dime, you know. But I spent it with pleasure because with that I wrote the book to alert the American people of the possibility of dictatorship. And that's where the dictatorships begin.
I agree.
So I used them, they used me and I used them to alert the American people. And that was the idea of the book. Naturally, it needs to be read. The reading needs to be intellectual, otherwise they don't understand what I'm driving at.
Right.
The reason why I posted those transcripts is to show how people lie on their oath.
Right.
It shows how the judges operate without making the proper legal interpretation.
Right.
Plus, it appears quite vividly that they can be manipulated, especially in Florida, especially in Charlotte County area.
Yeah. Well, I guess anywhere there's a lot of money, there are a lot of people trying to get to it.
Everything translates to greed.
Yeah.
And equals to cash.
Yeah. It's a shame. People don't have morality anymore.
No. Well, the morale of the country is broken across the board.
Yeah.
In a country without moral fiber, believe me, they're asking for troubles.
I totally agree.
Then when you get populism involved in politics, and you look at the history, and look at the way Hitler, Stalin and Mussolini came to power. That tells you the story right there. They came to power through populism. By building fear into the people, they took over.
It was written by Mr. Coliani, and I have his interview. You probably have seen him already in this video. And he sued the Gardens of Gulf Cove. And in this book, there is an affidavit from a former officer of the HOA. She was secretary. Her name was Patricia Hull. And in this deposition that she gave, she said there were, and that's what he sued for, voting irregularities that he observed in around 2009, 2010. And in one of her, in her deposition, one of the lines basically says, let's see if I can find it, it's right here. It says, the person interviewing her says, and what was the difference, do you recall, between the people that were there and the votes that were there as opposed to what was actually counted? No, I would say 25 to 30. Okay, and without these additional votes, is it your testimony that the bylaws would not have passed? Right. So she says, okay, so that was the difference, the 30 additional votes? Well, I don't know that the bylaws would not have passed at that time, but I'm not sure exactly how. So basically what they were saying is that 25 or 30 votes came out of nowhere. Now, if you remember the beginning statement, which is lawyers gain control of a regulatory association, I'm claiming that when this odd voting of bylaws was introduced was the date that changed the due date for annual payments from 3/1, which had been in effect since 1973, to 1/1. And further in her testimony, she says that most of the homeowners were never notified of voting. And I guess we never were notified because not only was I not notified, but there was an elderly lady named Louise Grizel who was a neighbor of Mr. Coliani. And he gave a deposition here also, basically stating why he sued and talking about the letter that she gave him. And Mr. Caliani's affidavit says, I, William D. Caliani, was a resident of the Gardens of Gulf Cove, POA, subdivision for approximately 14 years. I have moved back to Illinois in 2014 due to poor health. I am 88 years old. During the time that I lived in the Gardens of Gulf Cove, I noted infractions and unlawful activities by the board and management of the association that led me and others to file case number 1000049CC in Charlotte County. The case involved special assessments added to the regular annual assessment without proper membership voting, improper voting by manipulating the ballots, finding members for minor infractions, harassing members for undue causes. If the members asked for an extension of time to pay the annual assessment, they were refused, and the association sent the bill to collection by the association's law firm. I and another resident went with Jim McMahon, a neighbor, to the association's attorney in Bradenton, Florida, to avoid a lien and possible foreclosure of Jim McMahon's house. The payment of about $550 was for the annual assessment fee and a payment for the attorney collection agency letter. And that's also important to remember. Cannot charge for a letter, and I'll tell you why. Furthermore, Louise Grizel, my dear friend and neighbor, received a similar collection letter while her husband was in hospice care. When she received the collection letter, she came to my house crying because the bill was overlooked due to the circumstances. The association, which previously would have contacted her first, instead sent the bill to the lawyers who added their own collection fee, and I'm claiming that's what this is all about, collection fees for the law firm. Now I do assert that the attached copy of the letter written by Louise Grizel to Jack Arlinghouse, the then president of the association, and signed by her in disgust, was given to me personally by Louise Grizel, and an attested copy of Louise Grizel's letter is here attached. In the course of the legal proceeding and the production of documents, an association's trial lawyer produced falsified documents during the discovery period, which I identified as fraudulent. I affirm that the documentation in my book, Democracy or Dictatorship, which I wrote about the Gardens of Gulf Cove, is true and correct. I affirm that Patricia Hull's deposition in the book is a true transfer from the original. So I'm going to read to you a little bit from Louise Grizel's letter that she sent to Jack Arlinghouse, the then president of the Gardens of Gulf Cove Property Owners Association. It's dated May 28, 2010, and this letter was provided me and is attested to by William Caliani, who was her neighbor. At the time she wrote this letter, poor Miss Grizel was 87 years old. It says, on Thursday, May 27, 2001, received a letter from Richard Weller, representing Najmi Thompson Law Firm. I'm going to skip a little bits and pieces. After receiving the letter, I contacted the attorney's office in Bradenton and obtained a correct figure for payment of my past due assessment, plus interest fees and attorney's cost, a total of $589 instead of $300, and put my check in the mail. This letter is to express my disgust at the way this matter was handled by the POA Board of Directors, compounded by an attorney's office that couldn't get the right letter sent the first time. My husband and I built our home in the Gardens of Gulf Cove in 1980 and moved in as permanent residents in November of 1981. In the 29 years we've been there, we have always paid our assessments, usually promptly, usually in February of the year they were due, understanding that delinquency was 3-1. And I'm going to show you this letter with my finger where she has 3-1 as a delinquency, and she understands it to be 3-1 as of 2010. And what I'm going to further show you is somehow, and I believe it was during the time of the lawsuit, picking up oddities in voting, the lawyers, it's my contention, I don't know positively, but somebody changed the date, and the lawyers have it on my lien as 1-1, which meant they backed up the due date 60 days. But they can't back up the due date 60 days. It's impossible because we paid from 3-1 to the minute before 3-1 of the following year. Therefore, January and February were already paid. They can't assess late fees for months that were paid by the previous year's payment. So unless they gave a refund, which they did not, nobody can be late and everything is still due on 3/1 unless they were a brand new owner. But everybody else who's been paying for years on 3/1 should not be late. And I believe they did that to make people who would be 30 days late, such as myself, 90 days late so they could generate a letter. And this letter is not lawful. And that is what I disputed, and that's what this lawsuit is all about, is I disputed under the Fair Debt Collection Practices Act, and they sent me the letter under that act, but charging for communication is unlawful, and I will show you where the Fair Debt Collection Practices Act counts that as an unfair collection practice. So she thought that the delinquency was 3/1, and it says to receive such a notice from the board's attorneys without any prior notification from the Gardens of Gulf Cove office, to questions such a notice from the board's attorney, without any prior notification from the office of a missed payment, i.e. a telephone call, email, or letter, is unconscionable, even illegal. My husband, due to be 90 years old in 3 months, has been hospitalized 5 times since November 2009 and is currently in the hospital, Fawcett Memorial. When I first received the notice in December, the assessment notice for 2009, I put it aside to be paid as usual in February of the year it was due, 2010. With all of my spouse's health issues, the notice got pushed back in my file and overlooked. After receiving the letter about non-payment, I checked my records and found that although I thought I had paid it, actually the last payment was February of 2009, not 2010. The added stress, which I do not need at this time, caused by receiving this notice from the attorneys, could so easily have been avoided by a simple follow-up telephone call. If I didn't have more important issues on my mind at present, I too would join others in this development who have sued the board, written letters to the newspaper, etc., etc. In my 87 years, I have never been behind in any payments I owed and find the handling of this matter reprehensible. In disgust, Louise Grizel, Mrs. Henry Grizel, and Mr. Colliani attached Mr. Grizel's obituary from just a couple of months after this letter was written. So it shows that they changed the due date, that everybody else didn't know about it, and that they were generating legal fees. And those legal fees came in a letter, say 90 days would come up beginning of April, because you have January 1st, 30, February, March, beginning of April is over 90 days now. And you have to be 90 days late for them to generate a collection. So that is my conclusion why the dates were changed. Hi, Mr. Bergman. This is Christine Marfut, and I just wanted to interview you for my video about HOA fraud. I'm calling it a super scam. I'm a victim of it right now, and I'm fighting it tooth and nail. So I wondered if you could tell us a little bit how you became involved in fighting what you see as injustice in HOA, and just tell us something about yourself and your organization.
Well, I got involved when I moved to Florida into an HOA. At that time, I didn't even know what an HOA is. And I moved into a community where the developer cheated us back and forward. So we sued him and then found out that he used our maintenance fees to pay his attorney. When we got to Tallahassee, we were told, well, there's no money to fight these developers. So we founded the CCFJ as an advocacy group because, united we stand. You need numbers because we don't have the money the service providers have, because they're using our money to lobby in Tallahassee for their laws against us. And the laws actually allow the owners to be in charge. The only problem is that many of the owners don't want to hear anything about it. They want to live a peaceful life and not get involved in community association politics. And that allows often a small minority with private agendas to run the show and to become dictators in a community where the apathy of the owners is their biggest enemy.
Right. There is a community, I'm not sure if you're familiar with it. I live in the Gardens of Gulf Cove, and I'm fighting them, but I became aware that there's another community, and they are up in arms trying to fight. It's called Section 23. Have you heard of them? And
Since many years.
Yes, and I had one of the neighbors gave me a sale by the clerk of the court of his neighbor's house, and it sold literally for 1 penny on the dollar. It was a 3-bedroom, 2-bath, caged-in pool, valued at approximately $140,000. It sold back to Section 23 for $1,400 in 3 minutes. And in my lawsuit, they want me to be held responsible for deficiencies. So I guess they're planning that my house would sell equally cheaply, so then they could go after any other property I own. So it's a way to totally defraud a person of everything they've ever worked for.
That is correct. But see, you have to realize one thing. Everybody here in Florida who wants to rob a bank must be a total idiot. Because robbing a bank might get him $20,000, maybe $30,000 if he's lucky, right?
Right.
So, but if they catch him, he ends up in jail for 20 or 30 years, and the FBI is after him. No, become elected to a board of a community association, embezzle a few $100,000, and even if they catch you, they slap you on the wrist and say, "Oh, please don't do that again."
Well,
that's the reason why you have so many scams and so much embezzled money in the millions. We followed over the years all these cases, and the $1-2 million is nothing. Not too far away from you, $1.9 million were embezzled by a CAM, and nobody cared.
Embezzled by whom?
By a CAM, a community association manager.
Okay. Oh, yes.
And nothing really happens with these people. In Hallandale, 4 guys embezzled $1.4 million, and in the end, only one got in the courtroom, and the judge said, "Why, you're too old to send you to jail." So what I do is, you go on probation, and in the end, when you die, the association gets your unit, which is a total joke.
Well, the other thing, too, is that most of the people making the money are the lawyers. And, you look at them as being pretty much upright people. They have the suit, the tie, the degree, and they're the ones who are cashing in on this. And they fine you, and the lawyers make money.
But only because the board allows them to do it.
Well, the board should be equally responsible and held to account for fraud.
See, an association is a business. Most of the people you have sitting on the boards are not business people.
Right.
They don't understand what is going on. So, because they want to be in power, because power is almighty, they have a CAM, a community association manager, and an attorney who they listen to and allow them to run the show. Because there are some people who like to be called Mr. President.
Mm-hmm.
Right? And that's why they are the president of the board. See, you have to understand the mentality of the people. And the old saying, power corrupts, and
Yes.
more power corrupts even more. And that is what you see in these communities. And considering the fact that there is more or less no regulatory agency for HOAs and nobody enforces the laws, everybody can do whatever they want. And you have to understand that this board has all the money in the world to pay attorneys up the yahoo, while the poor owner barely has the money to pay the retainer, much less that. And a lot of these specialized attorneys know full well that the owners don't have the money really to pay expensive attorneys, so they play for time, meaning they file motion over motion, trying to bleed the owner dry financially. And that is the whole trick, because they know on merits they couldn't win, but they can win because the owner runs out of money. And there's nobody to create enforcement and nobody to help the owners. And that's just the way it is. And while the board comes with high-paid attorneys, you are happy to hire somebody from around the corner who charges a few bucks to defend you.
Right, and they would want to settle and get it over with. They really don't want to stop what is really, there's a lawyer in Texas who sent me an email. She's a criminal defense attorney, and I'm so surprised that she said this. She said the HOA is a crime syndicate. She said they make her nauseous and they should be jailed, taking old people's houses, and she really laid it on the line in the email, and I was surprised. And I think that's really what needs to be done to straighten up this country and this huge amount of money.
There is a bill pending in Tallahassee at the moment, which makes all kinds of stuff like kickbacks and embezzlement felonies.
Well, I just noticed that to file a false lien against real property, I think it's Florida statute 817.535. It says anyone who files a false lien against real property is guilty of a felony in the third degree. And I can prove the liens are false.
Right, but how do you prove?
Well,
they say, oh, the community association manager gave me the note that you didn't pay, so he is at fault. I just did do what the board told me. You know, I always call all these excuses what the Nuremberg defense.
Right.
You know, Adolf told me and I did it. You know, there the state attorneys were Americans and they didn't allow this defense to happen. But now the defense works really well because they always blame somebody else. And normally they blame the board because in reality the board is the executive who makes a decision, and you can make the decision whether to file or not. So the so-called service providers are always well off and never get caught. But see, the board says, or the board members, if you accuse them of filing a false lien, they will say, okay, we didn't know better because the CAM we employ gave us false numbers and we relied on the numbers, so they were done. So the CAM comes and says, yeah, but the board told me, you know, if he didn't pay, it's, you know, I do this now 20 years. Believe me, I've heard it all, and it never fails to work. You know, they have excuses over excuses, and in the end, nobody is liable, and the owners in the end don't have the money to really pursue the case. That's it, and that's what they rely on. But what is still missing is the enforcement, because don't forget, the best law is useless without enforcement.
That's right.
You know, what do I say? You know, if the board member embezzles $100,000, he goes to jail. Only there's nobody who sends him to jail.
Right. I totally agree.
State attorney's offices in many cases says, well, you know, he didn't know better, and you know, if he repays, you know, it's not worth prosecuting. You know, we have bigger cases than bigger fish to fry.
Well, my goal too is to, because this is such a drain on the economy, you're having people losing the roofs over their heads. They can be depleted through the sale of cheap sale of property, of everything they ever own. In a way, they're also affecting the next generation, the children, who are deprived of their rightful inheritance and a start in life. This is really something that needs to be addressed by the government, by people in the judiciary, and because these are officers of the court which are doing this, and they're doing it with the enforcement and blessing of the courts. They are ruining families, and I hope that this video will inspire people to put a stop, at least try to put a stop to all this chicanery that's going on.
You have to understand one thing. This is a $1 billion business.
Yeah, $1 billion scam.
Yeah, well, see, look, for example, I'm originally from Germany. In Germany, condo and homeowners associations are illegal. In the homeowners association, in former times, when you had neighbors in need, you brought some chicken soup and cookies and wished them well. Nowadays, you bring some liens, lawsuits, and all foreclosure notices, and that's the neighborhood. And here goes the neighborhood.
This is from the Gardens of Gulf Cove. I never was sent this. I got this from a person who lives in my community. And it shows that my property, legal, Drucker, is now being assessed at over $7,000. I'm a line item on the billing. So not only is my privacy being invaded by telling my neighbors that I have legal fees, but they are being charged to defray them. So that's what I said. The Gardens doesn't pay, the homeowners pay. And in this case, if they're defrauding me and they're defrauding everyone else, and they are by charging them to commit fraud.
Please keep it down.
Yes, I came because I'm an item on your expenses. And you probably remember me. You gave me the best compliment I ever had in my life. I was coughing in the bathroom in Northport, and I said, maybe I should just let Northport take everything. Maybe I'll die and let them have it all. And you said, you're too ornery to die. You gave me a big hug. Well, the person who was doing lawsuits against homeowners at that time has since been found guilty and admonished or fined by the governor of Florida for misuse of position with corrupt intent. So I'm here just kind of because I think you all are pretty good people, and I want you to know that I'm a good person. But I have been sued unmercifully for items that I've already paid for. So and I have my canceled checks, but I'm being sued for failure to pay assessment.
This is a lawsuit. This
It is, and I know you can't discuss it.
It cannot be discussed here, but we can't.
I'm not discussing it with you, I'm just stating my point, which is that I can prove that 2 liens, and I don't even know if you know that the second lien was filed. I'm not asking you to say anything. I'm just saying that the second lien, you don't want to hear this, so that it's for your benefit.
I'm not going to listen to it, man.
Okay, well, I just want to know that I'm trying to tell you that he's going to file for it. All right, don't listen to the lawyers. someone has to, jail. No, but what I'm trying to say I've been to one of the meetings. I tried to tell them they've issued false liens and to look into it. I was totally ignored. Matter of fact, basically ran away from me and said, la, 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 we don't want to hear anything. So I was trying to tell them, you're really committing a felony, but nobody cares. And now I'd like to present my evidence of fraud, racketeering, things which are felonies, which are the filing of false liens against my property, and show you the codes, both federal and Florida, which make the actions filed against me criminal. I'm fighting because I paid a month late my annual dues and added a late fee with a note when I dropped it in the drop box. I transplanted some flowers. That's all I've done. I fought 2 years. I have questions about the court. I'm not the only one with questions why this was filed in a lower court, which I have claimed does not have jurisdiction. And I want to go over that with you too and show you what seems very, very odd by both the judge and the Nashmi Thompson lawyers for the association. Okay, so basically, as I've said, the pretense for this lawsuit, and I say pretense, is failure to pay annual assessments, which is false because I paid them all. So that is a false lien. It's a false lawsuit. And they don't want just a slap on the wrist for me. They want everything. It says at number 16 of the lawsuits that the court should A, take jurisdiction of this cause and of the parties to this action, one of them which is me, ascertain the amount of money, including interest, expenses, costs, and attorney's fees that plaintiff is entitled to recover. The plaintiff is the Gardens Gulf Code. Adjudge that a plaintiff has a lien on the real estate of the defendant as described herein, which is the $327.50, for the sum of money found to be due, and that this lien is superior to the rights, title, and interest of the defendant. B, order that the lien be foreclosed in accordance with the declaration of Florida Statute 720.305. Funny they should mention that, even though they violate it continually. And the established rules and practices of the court that on a default of payment to plaintiff of the amount so found to be due, the real estate be sold by the clerk of the court to satisfy plaintiff's lien, and that a deficiency judgment be entered against defendant for the sum remaining unpaid. Deficiency judgment is very important because I will show you that these houses sell and have sold, not in my development, but in a nearby HOA. I have the record of a sale, 1 penny on the dollar. That means the whole house is forfeited, and the owner can be held responsible for anything they want to make up to charge that owner, and therefore they can go after any other property. They want to incorporate into the judgment of foreclosure an order dispossessing defendant and requiring that the purchaser at the foreclosure sale and the purchaser's representatives or assigns be let into possession of the property. And they are to be awarded any other further relief as plaintiff may be entitled to receive. So they want the house. They want to kick me out of my fully paid for house for an amount that was already paid, and they know it was paid. This has been going on for 2 years. They know it. It is now malicious prosecution. The Gardens of Gulf Cove, through their attorneys, Nashmi Thompson, filed a lien against my property in 2012, claiming that I failed to pay my annual assessment fee of $327.50. This lien is false. The reason for filing it and claiming that I did not pay my assessment is to get the property, because a homesteaded property cannot be taken unless the annual homeowners dues are not paid. The reason for this is that they are voluntary payments in the same manner as a mortgage. And that is why these lawyers in every document threaten the foreclosure of property in the same manner as a mortgage foreclosure. But I will show you that this first lien and a subsequent lien are completely false. And as I stated before, Florida Statute 817.535 2A says, a person who files, which would be the lawyers, or directs a filer to file, which would be the association, with the intent to defraud, which is to steal my house, or harass, it's been 2 years of suffering for me, another, any instrument containing a materially false, fictitious, or fraudulent statement or representation that purports to affect an owner's interest in the property described in the instrument commits a felony in the 3rd degree, punishable as provided in other Florida statutes. A says a person who violates paragraph A a second or subsequent time commits a felony of the 2nd degree, which is more serious and is punishable by other Florida statutes. So I'm going to show you that this lien, which is the whole reason for being for this lawsuit, as the lawyers state, is false because I have the canceled checks. I paid not just $327.50, I paid $40, 2 months before this lien was filed. The lawyers themselves declare this lien to be fraudulent the very next day, for they send me another letter that says the amount is no longer $327.50, it's now $285. So no, they are sending me differing amounts. They're false because I paid the whole thing, but they contradict their own paperwork. This is the claim of lien. They actually, annual assessment, they've changed the date. The date was always 3/1. It's my contention that this is also a fraud, is to change the date to back up due dates 60 days so that they can then file a $250 letter. But the total amount, they say, is $302.50 plus a $25 special assessment for the total amount of $327.50. And the date on this is the 23rd of May, 2012. Gardens of Gulf Cove Property Owners Association, signed by Stephen W. Thompson, agent for Gardens of Gulf Cove. And it is notarized by Michelle. Can't read her last name, but that's it. And she must be in their office. There it is. Grantham. So, Mr. Thompson, partner in Nashmi Thompson, has notarized his signature, attesting to this claim of lien. This is my canceled check. I paid in the amount of, let's see if I can close in on it, $340, April 6, 2012, Christine Marfut, and it was for my address, 6313 Drucker Circle, and it shows at the bottom that it is an attested, that the image shown, it's an attested copy signed by a member of the bank. So this shows that I paid that year, plus I've paid for I have 12 years of canceled checks. You can see others. There is not a payment missing. So to say that I have missed a payment is completely fraudulent. Now, I also want to show you this letter. Okay, so this is a letter from Stephen Thompson of Nashmi Thompson, and the date on the letter is the very next day from the date on the lien. This date is May 24th, 2012, and it's sent by certified mail. And at one time, my corporation, my nonprofit, which I tried to start, had title to the property, but that is long over with. And it says this is an attempt to collect a debt. I had already written him back that I had paid my assessment in full, but what they're trying to get, and what you will see on here, is a $250 non-specific attorney's fees, which is what this whole thing is about. Everything is about attorney's fees. It is not a sincere attempt to collect a debt. It is for the ulterior motive of collecting for the association. So this was written on May 24th, and this is now the amount that they said the day after. Unpaid portion of assessments is no longer $327.50, it's now $285.60. Okay, and they filed this false lien, and I assumed the $150 is for filing a false lien, and they have very creative math. The other thing that's it's Nashmi Thompson signature, and this is filed by them, notice required by the Fair Debt Collection Practices Act, which they completely violate, and I will tell you how. So basically, somebody, unbeknownst to the homeowners, changed the date, the due date, which had been in effect since 1973 as 3/1. They backed it up to 1/1. I'm claiming that's an impossible task because the previous year we paid from 3/1 to a minute before 3/1 of the following year. We already paid for January and February. So it's impossible to count January and February as late. It's impossible to change the date unless you give a refund for those months. But they changed the date anyway. My claim is to send this letter for which they would charge $250. Now, I've already said I refuse to pay for an unspecified amount of attorney's fees. They can't specify it because I'm not their client. I'm not privileged to that information. They send the letter under the Fair Debt Collection Practices Act, and you can't charge for a letter under that act. So they're quoting the Fair Debt Collection Practices Act and violating it in the same breath. And this is why it is a violation. Fair Debt Collection Practices Act 8085 states, the following conduct is a violation of this section, causing charges to be made to any person for communication by the concealment of the true purpose of the communication. Such charges include, but are not limited to, collect telephone calls and telegram fees. And of course, that would mean a letter fee. And the concealment of the true purpose is not the collection of debt. It is the profit to the law firm of $250. Okay, so what I'm showing you is this is the first letter, April 3rd, 2012. Now, it has been since 1973 that all annual payments were due on March 1st. Mr. Coliani, a resident of the neighborhood at that time, filed suit because he noticed voting fraud. For some reason, the date was backed up to January 1st without telling anyone, without proper voting, as he observed. So anyway, this is what I want to show you. April 3rd, and what they want is, see if I can show you this. They have the $250 for attorney's fees, unspecified. And it is also written, signed by Stephen Thompson and firm principal, from Najmi Thompson, and it is also filed under the Fair Debt Collections Practices Act. So I wrote them back that I had already paid the amount in full and that I refused to pay $250 for an unspecified collection letter because, number one, I'm not their client. It's already been paid. It's an unnecessary amount. And this $250, they can't give me an invoice. I'm not their client. Can't bill me directly. I'm not their client. Anything that is connected with what this $250 is for is between the client and the lawyer. It's client work product, attorney work product privilege. So I'm not paying for something I don't know what it's for, and they can't tell me. And it's unlawful. There is a newspaper article from that time where it says that elderly people who had been in their houses 35 or 40 years were now getting threatened with foreclosure because for some reason they neglected to pay their association fee, which normally they would have just gotten a reminder. But instead they get this $250 letter. Apparently in 2010, when Mr. Caliano sued, there were 90 residents who were behind, which came to more than $20,000, which is no small check for the Najmi Thompson law firm. This is an article in the Herald Tribune. Homeowners Association battle threatens homes. It was August 21st, 2010. Homes at stake as Charlotte community battles with its homeowners association. And it is a time when Kalyani sued, and it says about 90 residents of the Gardens of Gulf Cove near State Road 776 and Placida Road are suing the association that manages the community and the local board of directors. Their attorney, Barbara Stage, said the board illegally amended association rules to gain greater control over the budget and dues assessments. Bill Colleen at the time was 80 years old. He said changes were made without a vote by homeowners who want the original rules restored. Talks about 90 homeowners have received intent to lien letters over late dues without receiving bills or late payment notices. But Stage said it is common for HOAs to play dirty when they are sued, and the lien process is a moneymaker. Resident and plaintiff James McMahon noted that he was charged $256 in attorney's fees multiplied by 90 residents. That is about $23,000. So, resident Pat Conklin-Hoole said an 89-year-old widower who broke his hip and was hospitalized returned home to find a letter demanding $600 in late dues and fees. He was able to pay the bill. There was a 93-year-old woman, and they told her, if you don't pay your dues, we're going to take your home away from you, said Conklin-Hoole, 73. You can't do that to somebody who's lived in their house 30 or 35 years. This is a letter, the original letter, that accompanied this exactly $30,000 lien. And it is from Stephen W. Thompson. It is dated March 11th, 2016. This is to inform you. Well, at first it says, as you are aware, the law firm represents the Gardens of Gulf Cove Property Owners Association. The association has retained this law firm to collect past due compliance fines owed to the association. Now, the $30,000 is grossly in excess of the limit imposed by Florida Statute 720, which limits association fines to $1,000, not $30,000. This letter is to inform you that a claim of lien has been filed against your property, and you have not paid outstanding compliance fines to the association. As of this date of this letter, the total amount due is $30,465.10. All costs of any action from this date forward will also be charged to your account. The association documents authorize the association to file a lien against your property and to foreclose the lien. The lien may be foreclosed by an action at law in the name of the association in a manner similar to the foreclosure of a mortgage on real property. Now, this is quite interesting here. Because of the additional attorney's fees and other charges may vary from day to day, the amount due on the day you pay may be greater. Hence, we suggest that you call our office and request a current payoff amount prior to sending your payment. Once you have confirmed with our office the full amount due, please transmit a money order or bank check for the full amount made payable to Najmi Thompson, P.L., to the attention of the collections clerk. So I'm going to show you this letter. Okay, here is the letter, the date, and I'm going to just go on down so you can see, if you want to see that I've read it pretty much verbatim. And this is the interesting paragraph right here that you may want to give it a look, see. And what is disturbing to me is that it says to send the check directly to the law firm made payable to the law firm. Now, what would prevent the law firm from cashing the check and just putting it in their account and never telling the client that they collected $30,000? This is more plausible than you think, because on the date, the claim of lien, again, here's the original. Sorry, that's not it. Here it is right here. The date that the original claim of lien came through, you will see it is 9/24/15. And that happens to be the date that my husband went to a meeting to which nobody came, and the association manager gave him a printout printed on 9/24/15 with no $30,000 listed. Nobody came to create a $30,000 debt. There's no $30,000 debt listed on the ledger. So where did it come from? This $30,000 check is going to go to Najmi Thompson, made out to Najmi Thompson as legitimate attorney's fees. They could cash it, pay taxes on it. Nobody would ever know. The client wouldn't know. Who's going to tell? Am I going to go after them? Well, I am. But normally a person would pay it, and that would be the end of it. As I showed you before, the date on that claim of lien was 9/24/15. I want to show you this, 9/24/15. This is a ledger which was printed. It states 720, which is the written by Jack Sheehan, who put his number at the bottom and signed it. And this was obtained by my husband when he went to protest a $3,200 crazy fine without any rationale. A shed that had been there for over 10 years, just circled. Flowers that I transplanted called weeds. I was fined into the future. You'll see that in a moment too. Anyway, where is cherchez the 30,000? There is no 30,000 listed on this printout. My husband went to question 3,200, but there is no 30,000. So this basically, and it's the date, nobody came to the meeting to create a $30,000 debt. There's no $30,000 on the date that the lien says that it was due, and I'm going to grab the lien again. See? 9/24/15. No 30,000. So what would prevent the Najmi Thompson firm from creating this lien, getting the check for the lien, and never telling their client that they got it? Very odd. This picture is a little grainy, but this is what we got in the mail. It was dated 8/20/2014. It's hard to see here, but it's a shed, our shed circled. And these are flowers in the front that I had transplanted, vinca, purple. They hadn't bloomed yet, but they were flowers. This is the invoice that came. Again, notice the date, 8/20/14, 1436. It's the time. Understand what that meant. So my husband weed whacked around the shed. Well, 5 days later, on 8/25/14, we get an invoice, Gardens of Gulf Cove, and this is for fines storage shed, 16 times $100, $1,600. This is weeds, flowers, $1,600, $1,600. Now, not only does this violate the Florida Statute 720, limiting it to $1,000, it is only 5 days after the picture notice, which means they fined me for 16 days, 5 days afterwards. So they are fining me for 11 days into the future, and the total is $3,200, 10 times our annual assessment fee. This is what my husband went to a mandatory meeting to discuss when nobody came. And Mr. Thompson, I guess, decided to make it $30,000 on the date he attended, 9/24/15. Okay, this is the letter that we received from the association, and it is to be 9/24/15, 10 a.m. And that is the meeting that my husband went to. Nobody came. And he wrote at the bottom, where is it here? Shoot, can't find it. There. That Al had come in, my husband, and he said that 10 years or more, 11 years after the shed was erected, without, the county didn't require a permit, it's under 100 square feet, Rubbermaid, it said mail in a shed request. That was just weird, so many years after the fact. I think that's what they wanted. We don't know for sure. It's only circled on the document that was given to us, which is, again, the shed circled in the back there, just circled, and the date 8/20/2014. But I have other questions about how this is being handled. Not only is this for a fraudulent lien, a felony to file against me, but also it was filed in a low court. Both Florida statute and Florida Constitution state that all cases, meaning no exceptions, which involve ejectment. Ejectment is the eviction of someone with title, which would be me. Free and clear house. All actions which involve ejectment and all actions which involve possession of and title to real property must be in the exclusive original jurisdiction of the circuit court. The circuit court is higher than the county court. For me, that means that this case should have been filed in the circuit court to begin with. So why go to the county court? These people are experts. Why go to Judge Burns? why did Judge Burns deny my counterclaim? I filed a counterclaim, which is my right. He denied it, not on any basis of legal mistakes that I made. I felt that I wrote a pretty good counterclaim. I stated all the laws that they had broken. I gave evidence of what they had done to me. And he told me that I would have to have my counterclaim signed by a member of the Florida Bar, or he would dismiss it, which he did. I believe that he did this to me now. I believe it now, that his actions were to keep the case in his court, because his court has a $15,000 maximum financial jurisdiction. My counterclaim was for more than $15,000, which would have automatically put the amount of controversy in excess of his court's monetary amount. I believe that the value of the house, which is almost $150,000, it's almost 10 times the jurisdiction amount of his court, puts it outside the jurisdiction of his court. The other thing that's very curious, I filed a motion and I asked for a hearing and on the jurisdiction, because as you will see, the association, or either Nashmi Thompson, Mr. Thompson by himself, it's hard to tell, but it's suspicious, filed a second false lien against me for $30,000. And I filed a motion that said this $30,000, because they want payment for all liens in this case, puts it outside the financial jurisdiction of the court. Guess what? Randolph Smith of Nashmi Thompson, who appeared in court, said to the court, "We have released this lien to render moot my contention that the $30,000 lien, which they released, put this case outside of Burns's jurisdiction." So you have the judge having me have my claims signed so that I won't be able to have a counterclaim, which would put it outside of his court. And now the law firm for the Gardens of Gulf Cove is releasing a $30,000 lien, which is no small amount, so that this case stays in Judge Burns's court. The other thing that's odd is that I filed my motion that said this case exceeds the financial jurisdiction of Burns's court. Somehow, my motion was changed to motion to transfer to circuit court. I never made that motion. Why would I want to transfer this case? I said it is filed in the wrong court, and it should be in the exclusive original jurisdiction of the other court. It should start in the other court. It cannot be transferred there. But the judge changed my motion to read otherwise and then denied it. That also is very, very odd. And when someone challenges jurisdiction, and I have cause to challenge it, I have Florida statute and Florida Constitution clearly stating that this should not be in this court, everything is supposed to stop at that moment. But Burns kept scheduling me for trial. 2 weeks, a month, hardly time to get people together, run this case through. Now, I'm not the only one who was before Burns. There's another person from a different subdivision. He's been suing for years to try to get his house back. He actually sued Judge Burns. He has sued Rico, as have I. And he said that Burns sold his house while it was in bankruptcy for protection. He said that Burns denied him a counterclaim, and he believes for the same reason, to keep the case within his jurisdiction. All these things are odd and need to be looked into. Because how are homeowners going to get a fair shake if things are being filed under a specific judge in a wrong jurisdiction? Anything that's filed in a court which lacks subject matter jurisdiction or financial jurisdiction is void ab initio, void from the beginning. It means it is as if it was never there. So if my house were sold by a court without authority, that sale never took place. This is a very complicated issue, and we need help checking it out. Now, not only is the date on the claim of lien odd, this is the release of the $30,000 lien. It's also been recorded as a release of lien, and I'm claiming that this was done. It was done after my counterclaim was filed and then denied. I thought it was done because they were caught red-handed, creating huge amounts of fine. But on second thought, this claim of lien of $30,000 would have put the case again outside of Burns's jurisdiction, and Randolph L. Smith from the Najmi Thompson law firm, he stated in court that the lien was released to render moot my claim that the $30,000 put this case outside the jurisdiction of the county court, which has a $15,000 jurisdictional limit, and outside of Burns's jurisdiction. So there are so many questions, so many irregularities. Why would someone who claims that they have a valid lien suddenly release it?
There's one other thing. Just one more thing. With you, Lieutenant, there's always just one more thing. Do you have a problem with short-term...
This is the ledger. Remember the ledger? One more thing. Can we say criminal conversion? Embezzlement of my funds earmarked for another purpose? That $250 that I refused to pay, I'm not their client. It was an unlawful charge under the Fair Debt Collection Practices Act. It was paid. Legal fees. Subtracted from my payments. And $150 subtracted from my payments for legal fees. Converting money earmarked for another purpose is criminal conversion of my funds without my knowledge or consent. It's also known as embezzlement. And together it is $400. That is grand theft. So add that to the list of crimes.
Now, Mr. Lacey, you say this ad appears in your magazine, Lonely Hearts Calling?
You're thinking the ad is a fraud, aren't you, Mr. Drake?
I'm thinking.
So are the postal authorities. Unless I can satisfy them that the ad is genuine, they say that I'll be charged with using the mails to defraud. That's why I need your help as a private investigator, Mr. Drake.
I'll do some investigating. After all, I got a license to protect, and the postal authorities are involved in this, and I have no desire to tangle with those boys.
So not only I, but Albert Robinson, who has gone before me, we have both tried to file, and I am still in the process, I'm appealing. I filed a racketeering, a RICO case against the Gardens of Gulf Cove and the lawyers, including the current the current board and the past board. It's very hard to pin these people down because they come and go. They ruin your life. They order the sale of your property, and you can't even go back after them because they're not on the board anymore. They moved to another neighborhood. They did something. But so it makes it even harder to track down these people. But I filed a RICO complaint. Judge Chappelle denied my complaint even before I could start with interrogatories to get more information from the gardens of what's going on, how many people have they foreclosed on. I could not file interrogatories because she dismissed the case, saying that it was unadorned and it did not reach beyond the speculative level. And so I have currently appealed her decision, saying that she erred, that pro se litigants should have the advantage, which is granted them by law, because we're not experts, and also that she erred because my complaint is extremely well endowed, or adorned, I should say, with evidence. So I hope that the appeals court will realize, and hopefully this video, which is showing what a problem this situation is for homeowners who are, not only can they lose that roof over their heads and their stuff put out on the street and embarrassed in front of the neighbors, maligned for debts they don't even owe, but because of the way they structure this, and if houses are going for a penny on the dollar and you are responsible for deficiencies, they can come back and go after anything else you own now or anything else you will ever own. Your children do not get their inheritance. They don't even get the roof in their room. They're kicked out. So hopefully this video will inspire people who have the power to help the American homeowner, which is the backbone of industry. Homes generate a lot of manufacturing, windows, doors, appliances, furniture. Home ownership is wonderful, and people have worked their whole lives, and their whole lives' savings is in houses that are being stolen. Thank you, and let's go get them. I want to show you that the Gardens of Gulf Cove is not the only HOA suing its residents. This is from the Charlotte County Sun, and it is a political cartoon. It shows the Charlotte County Courthouse and so many Deep Creek Section 23 lawsuits that they have to put a drop box off to handle them all. Hi everybody, I just want to tell you that HOA fraud and taking people's property, kicking people out of their homes with their children, stealing their most valuable asset and the very roofs over their heads for minor things is everywhere. I'm talking with Larry, who's a resident of Section 23, a Deep Creek development also in Charlotte County, and his neighbor was evicted. He owned the property, was evicted from the property. The development itself, the corporation, Section 23, bought the property for $1,400. Is that right? And you found out about that?
Yes, that's how I learned the property, because after the association had foreclosed on the property, from what I learned, they purchased it at an auction. But they let the property go and there were rodents running around. I had to call the county. The county came out and told me that Section 23 owned the property through an auction. And that's when everything started, and I learned there was a group here, Take Back Section 23, that got together. I became a member of Cyber Citizens for Justice, and I wasn't aware of what was going on, but I learned that there was other properties that they purchased through foreclosure, and I'm wondering, I'm saying, is this a corporation, not for profit? Why are they? So I didn't understand it, and now that I've learned, I'm kind of protective of, what goes on in my property. Make sure you know, this, that, and the other thing is done. But again, they always tell you about uniformed enforcement. And I want someone to define uniformed enforcement, because it just doesn't make sense in the area. Anyways, that's it.
I saw a video by Albert Robinson where somebody, I don't know if it was from the association, or it must have been from the association, because I don't think the county would come out and say you have to add 2 bushes, or otherwise we're going to fine you.
Oh.
And anyway, they are so particular about every little blade, but you said when they owned the property, they let it go to pot and there were rodents. Grass was high, I take it?
Yeah, section 23.
And yet, when they own the property, they're not going to fine themselves.
Right, and I just didn't get it. And I was told, hey, you know, we get properties, you know, people don't pay whatever, so we just, you know, end up getting it because of whatever, and it didn't make sense.
And you said it was only like a $400 debt that he may have owned?
That was my understanding, $400-something he owed.
And then they sold it to themselves for $1,400, and
right.
You don't know what happened after that, but you know that somebody else has since bought it. And most of these cases seem to be going through the Charlotte County court system, and mine is too. So anyway, I just wanted to let everybody know that it's not just me, it's not just Gardens of Gulf Cove, it's other condo, or I could be condos as well, other homeowners associations within Charlotte County, within almost every county, I'm sure, of the whole United States. Families are suffering for very little, and they're losing everything. This is Charlotte County Clerk of Court. This is the sale of a property in Section 23. I talked to the neighbor, said the property was in good condition, a 3-bedroom, 2-bath, caged-in pool. Guess what? $1,400 is the purchaser, and the plaintiff bought it for $1,400. 2011. There it is, right there. So you have a $140,000 house selling back to the plaintiff for 1 penny on the dollar. And that's what's going to happen to my house. I have no doubt if it gets to court. This is the house that Larry was talking about. The family was evicted for a very small amount. The house sold for almost nothing. And the original purchaser is now without. And this is a beautiful house to go for $1,400. And Larry said that when they were here, it was beautiful. It was Section 23 itself, the association, that let the house run down.
This is new, right?
Everything's new.
They had to, did they bust that out?
Yes, bust this out. Everything had to be exchanged.
Terrence Flowers put his Southern Highlands home on the market when he moved his family to Florida, and it wasn't long before squatters broke in.
They damaged all of the doors
and tore the place up.
They took the pool equipment apart.
Terrence upended his life for a temporary move back to Las Vegas to confront the squatters.
They asked me who was I, and I told them I'm the owner of the house. They said, well, we stay here now, just slam the door.
He had to go through a formal eviction process to get them out and file a claim with his insurance company to repair the damage.
Squatters took the doorbell. It's the first time I ever seen something like that.
Then put the house back up for sale and returned to his family on the East Coast. You got to a point where you were finally able to sell your house, and then it comes to a screeching halt. What happened?
I have no clue. The house was sold 3 times. Cash offers. And it just blew my mind how all of a sudden it's just, the sale's no good.
Turns out, fines from his HOAs were stopping the sales. They were coming from both Solaro, the sub-association, and Master Association Southern Highlands for things like
missing trees, bushes.
Even the driveway gate, which the squatters destroyed.
The HOA started fining me every week for that.
And the amount of money the HOAs are demanding? I couldn't believe what I was reading. The amount of fines and fees that have racked up against this house from the HOA isn't just high, it's almost unheard of. In fact, as you can see by the number, it's so much you could literally use that money to buy a house.
$111,000 for fines, fees.
It doesn't happen. Realtor Julia Suarez says she's lost 5 buyers on this property, people who've walked away because of the HOA. They will not negotiate at all. So it sounds like you're kind of caught between a rock and a hard place. You
That's
can't
correct.
sell because of the fines. You can't leave because of the squatters.
Right.
It sounds like a circus.
It is a circus.
Terrence says he got no notice that the fines were racking up when Julia asked how they got to that exorbitant amount.
And we're not getting a complete detailed printout of $111,000.
The numbers on the documents don't add up. The demand letter from Southern Highlands shows a total amount due of about $112,000, while the resident transaction detail given to Terrence shows a balance of about $58,000. That's for October 2014 through September 2016. A collection agency is also looking for around $6,000 for Solaro, but their transaction detail shows a balance of $7,000.
It doesn't make sense. Even the title companies have never seen anything like this amount.
We called both Solaro and Southern Highlands as well as their management companies. No one has agreed to talk to us on camera, and so far they haven't answered our questions, leaving the house in limbo.
We can't close.
And Terrence's life on hold.
You know, I would be living in Florida, spending time with my kids, and I have to be here and sit here and babysit this house.
The only way to keep squatters at bay while he fights with his HOA.
They're not allowing me to move forward. This house would have been sold by now.
Believe it or not, the fines keep racking up. As of today, the Southern Highlands balance is now almost $158,000. But now that they're in the spotlight, the HOA may finally be willing to budge. We learned both Southern Highlands and Solaro reached out to Terrence's realtor, asking him to come to board meetings to discuss waiving some of the fines. Darcy Spears, 13 Action News.
I want to mention that a lawyer in Texas sent me an email, and I'd like to read it to you. She has a 5-star criminal defense lawyer, and she knows what's going on in HOAs, and a lot of people know, but it's very hard to stop. She says, the HOA is nothing but a crime syndicate. Your exact case is played out with way too many property owners. These people need to be jailed. You are ripe in their eyes for the pickings. A free and clear house, and the crime family wants it. HOA lawyers are pros in extortion and browbeating the unscrupulous into submission and either taking money unnecessarily or a poor widow's home. Makes me nauseous. Are you in Florida, Christine, or Texas? You definitely must write a state bar complaint and get the media involved. Pieces of trash. This is a copy of the email that I read to you from Paula Robnet Theodorio. And this is what she said. What I've already read to you, just to show you. Okay. Just to show you, I did not make this up. And thank you, Dr. Paula, for speaking out. There will be nothing left for their children to inherit. They will be ruined for the rest of their lives and will never have another house, but we will. In a separate deal, a Gulfront home on Holmes Beach sold for $5 million. Anne Marie Bordenov sold the half-acre property at 102 47th Street to a Sarasota company that immediately transferred ownership to companies headed by Brian Ween of Blue Bell, Pennsylvania, and the local Nashmi Thompson law firm. The property includes a 3-bedroom, 2-bath, 1,456 square foot home that was built in 1951. According to property records, it last sold for $2.45 million in 2007. This is the view from number 102, 47th Street, that is on the information for Najmi Thompson's recent $5 million purchase. And I'm going to pan around so that you can see the property, which was the yellow house right there. So nice to have it nice. Excuse me, sir. Are you Mr. Swampy? Are you the HOA lawyer?
Get that camera out of my face.
Are you the HOA lawyer that's taking people's homes?
Get that camera out of my face.
Kicking children out? I bet you're making a lot of money at it, aren't you?
Get that camera out
Do you
of
have
my
any
face.
comments?
No comment. No comment. See you in court.
I've seen lots of funny men. Some will rob you with a 6-gun, some with a fountain pen. As through this world you travel, as through this world you roam, you'll never see an outlaw drive a family from their home.
And a CNI production. Hello boys, I'm back.